Topic of today's lecture is introduction of legal provisions. Legal provisions for bringing on record legal representatives of deceased party in a suit. Legal representatives of deceased party. This lecture is useful for those who are conducting civil litigation matter in the court. So, on this particular topic of bringing on record the legal representatives of the deceased party in the suit, with respect to this particular topic, I will deliver lecture in about 6-7 video parts. So today I will just explain, or I will just tell what are the relevant provisions, legal provisions relating to this topic. This topic is related to the Code of Civil Procedure Code. In that Civil Procedure Code, there is Order 22, which contains various rules relating to this topic. Here, order means it is a heading given by the Civil Procedure Code for collection of certain rules relating to specific topics. So it is order means it is one sort of heading given to the collection of certain rules relating to specific topic. So Order 22, it talks about Order 22 of the Civil Procedure Code. It talks about what could be the effect of death of any party to the suit on a suit. So the relevant provisions, I will not tell all the provisions, but which are very important provisions. So Order 22, Rule 1, that is Rule 1 of Order 22. Its heading is no abatement by party's death if right to sue survives. The death of a plaintiff or a dependent shall not cause the suit to abate if the right to sue survives. So this is a general rule. Means in spite of the death of plaintiff or dependent, if right to sue means right to continue the proceeding of suit, if that right still survives, irrespective of the death of plaintiff or dependent, if such right to sue survives, then suit shall not abate. Abate means to come to an end, to finish. So suit shall not, the death of a plaintiff or dependent shall not cause the suit to abate if the right to sue survives. Right to sue, S-U-E, sue, survives. So this is general rule. Then Rule 2, its heading is procedure where one of several plaintiffs or dependent dies and right to sue survives. So Rule 2 take into consideration the situation that if there are plaintiffs, plaintiffs are more than one, or if there are dependents, it is more than one. So if there are several plaintiffs or several dependents, and out of the several plaintiffs, suppose one plaintiff dies, or out of the several dependents, suppose one dependent dies, but right to sue survives. So what is the effect? So Rule 2 of Order 22 says that where there are more plaintiffs or dependents than one, and any one of them dies, and where the right to sue survives to the surviving plaintiffs alone or against the surviving dependents alone, if the right to sue survives the surviving plaintiffs alone or against the surviving dependents alone, it means that the fact of death of that one plaintiff or one dependent, it is not matter. Irrespective of the death of that one plaintiff or one dependent, right to sue survives to the surviving plaintiffs alone or against the surviving dependents alone. That means the death of that one plaintiff or dependent doesn't make any difference. Then in this situation, the court shall cause an entry to be made on the record, and the suit shall proceed at the instance of surviving plaintiffs or against the surviving dependents. So this rule 2 says, irrespective of the death of that one plaintiff amongst the several or one dependent amongst the several, if this fact is not going to affect the continuation of the suit, because right to sue survives to the remaining plaintiffs or against the remaining dependents, then in that case suit proceeding will be continued. Now rule 3 of order 22. It tells procedure in case of death of one of several plaintiffs or death of sole plaintiff. So two situations. Firstly, this rule 3 is relating to only plaintiffs, not dependents. So first situation is that there are several plaintiffs and one of them dies, or there is only sole plaintiff and he or she dies. So in this respect, sub rule 1 of rule 3 says, where one or more plaintiff dies and the right to sue does not survive to the surviving plaintiffs alone, and the right to sue does not survive to the surviving plaintiffs alone. Here alone is very important word. Or where a sole plaintiff dies and the right to sue survives, then the court on an application made in that behalf shall cause the legal representative of the deceased plaintiff to be made a party and shall proceed with the suit. Firstly, we will consider the first situation. First situation is that there are several plaintiffs and one of them dies. Then if the situation is such that right to sue does not survive to the surviving plaintiffs alone, it means that it is very necessary for the continuation of the suit that legal representatives of the deceased plaintiff should be brought on record, otherwise suit cannot be proceeded with. Therefore, where one or more plaintiffs dies and right to sue does not survive to the surviving plaintiffs alone, that means in this case there is a necessity to bring on record the legal representatives of the deceased plaintiff. This is first situation. Or where second situation, where a sole plaintiff dies. Sole, only one plaintiff dies and right to sue survives. To whom it is survives right to sue? To the legal representatives of that deceased plaintiff. Then in that case, the court on an application made in that behalf, who has to make application? In case of several plaintiffs, one of them dies, that surviving plaintiffs has to make an application. In case of sole plaintiff who dies, then who has to make an application? Any such person who claims to be legal representative of that deceased plaintiff has to make an application before the court. So upon such application, the court shall cause the legal representative of the deceased plaintiff to be made a party and shall proceed with the suit. The sub rule 2 of rule 3 of order 22 further says that where within the time limited by law, no application is made under sub rule 1, no application is made for bringing the legal representatives on record of the deceased plaintiff, no application made, then the suit shall abate so far as the deceased plaintiff is concerned. So there is a one law, it is called as Law of Limitation Act 1963, and it prescribes the time for bringing legal representatives on record. So within the time prescribed by law, no application is made, then the suit shall abate. Abate means it comes to an end, it gets finished. Suit shall abate so far as the deceased plaintiff is concerned. So this is the rule 3 of order 22. Now we'll see rule 4 of order 22. Rule 4, it tells procedure in case of death of one of several dependents or of sole dependent. So this rule 4 of order 22 is relating to dependents, not plaintiffs. Here also there are two cases. First case is there are several dependents, that is more than one, and one of them dies. This is first situation. And second situation is there is only one dependent, that is sole dependent. Sub-rule 1 of rule 4 of this order 22 says where one of more dependent dies, and the right to sue does not survive against the surviving dependents alone, or where a sole dependent dies and the right to sue survives, then the court on an application made in their behalf shall cause the legal representative of the deceased dependents to be made a party and shall proceed with the suit. So here also there are two situations. First situation that there are several dependents and one of them dies. Now whether right to sue survives against the surviving dependents alone. If it is not survive against the surviving dependents alone, it means that there is a necessity to bring the legal representative of the deceased dependent on record, otherwise suit cannot be proceeded with. So this is the first situation. And second situation is that there is only sole dependent, one dependent, and he dies, and if the right to sue survives against the legal representative of that sole dependent, then it is necessary to bring those legal representative of the deceased dependent on record. Who has to make application here? Of course the plaintiff has to make application, because suit is instituted by the plaintiff. So upon such application made by the plaintiff, the court shall cause the legal representative of the deceased dependent to be made a party and shall proceed with the suit. Then sub-rule 2 says of this rule 4, any person who is so made a party as a dependent may make any defense which will be appropriate to his character as legal representative of the deceased dependent. So legal representative of deceased dependent has been brought on the record. Then whether that legal representative of that deceased dependent is entitled to take a defense in the suit? Answer is yes. But he is entitled to take such a defense which will be appropriate to his character as a legal representative of the deceased dependent. So he can take defense. Sub-rule 3 says, where within the time which is limited by law, that is Limitation Act, no application is made under sub-rule 1, application to bring the legal representatives of the deceased dependent on record. Where within the time limited by law, no application is made under sub-rule 1, then the suit shall abate as against the deceased dependent. Suit shall abate. Then sub-rule 5 of this rule 4 of order 22. That sub-rule 5 says, where plaintiff was ignorant of the death of a dependent. So this sub-rule 5 deals with that situation where plaintiff was not having any knowledge regarding death of a dependent, and therefore plaintiff could not for that reason make an application for the substitution of the legal representatives of the deceased dependent under this rule within the period as so specified in the Limitation Act, and the suit has in consequences abated. So it considered the situation, which situation? Plaintiff was ignorant about the death of the dependent, therefore he could not make an application for the substitution of legal representative of deceased dependent. He could not make such an application within the period as so specified in the Limitation Act, and therefore in consequences suit get automatically abated. Abated means suit get finished, ended. Then in such a situation, when later on plaintiff gets the knowledge of death of that dependent, later on when he gets the knowledge of the death of that dependent, then where later on the plaintiff applies after the expiry of the period specified therefore in the Limitation Act for setting aside the abatement. So in that Limitation Act, limitation period is prescribed for making such an application for setting aside the abatement. But now the plaintiff, because he was not having any knowledge about the death of the dependent, later on he got the knowledge. Till that time, the period which is prescribed by the Limitation Act for making such application get expired, and after the expiry of that period, he is now making an application for setting aside the abatement. Plaintiff is making application. So naturally now plaintiff is making application after delay, because he is making application after the expiry of the period, limitation period. And since because he is making the application after expiry of that period, that is after much delay, he is also making another application under section 5 of the Limitation Act. That another application is application for the condonation of delay. Condonation of delay in making an application for setting aside the abatement. So in such case, he also makes such application for condonation of delay on the ground that he had, by reason of such ignorance about the fact of death of that dependent, he had by reason of such ignorance sufficient cause for not making application within the period specified in the Limitation Act. So why he is having sufficient cause for not making that application for setting aside the abatement within the prescribed period of limitation, because he was ignorant about this fact of death of the dependent. Then in such case, this sub rule 5 of rule 4 of rule 22 says that, then in such case the court shall, in considering the application that is delay condonation application under section 5 of the Limitation Act, court shall have due regard to the fact of such ignorance of the death of the dependent, ignorance to the plaintiff, ignorance of the death of the dependent, if it is proved by the plaintiff. So we have considered this rule 4, which specifically deals with the death of dependent. Now next rule which is important, that is rule 9 of order 22. Its heading is effect of abatement or dismissal. So abatement, it is the effect of law that should get finished automatically, and when the suit get finished automatically, then the suit has to be dismissed by the court. Rule 9 sub rule 1. Where a suit abates or is dismissed under this order 22, then no fresh suit shall be brought on the same cause of action. So once a suit gets abated and dismissed, then plaintiff cannot bring any fresh suit on the same cause of action. Therefore, it is necessary that when plaintiff comes to know about the fact of abatement of the suit or dismissal of the suit, then he should be prompt in making an application for setting aside such order of abatement or dismissal. Therefore, the sub rule 2 of this rule 9 says, the plaintiff, or in case of death of sole plaintiff, any other person who is claiming himself to be the legal representative of this is plaintiff. So plaintiff has to make application. Also in case of death of the dependent, or when there are several plaintiffs, if in case of there is a death of one of the several plaintiffs, okay, plaintiff has to make an application. And when the case is such that there is only one plaintiff, sole plaintiff, and he died, then who has to make application? Any other person who is claiming himself to be the legal representative of this is plaintiff. So such person may apply, plaintiff or such person may apply for obtaining an order from the court to set aside the abatement or dismissal of a suit. So under this sub rule 2 of rule 9, plaintiff has to make an application for setting aside abatement or dismissal of a suit. And if it is proved that he was prevented by any sufficient cause from continuing the suit, then the court shall set aside the abatement or dismissal upon such terms as to cost or otherwise as it thinks fit. So when the plaintiff makes such an application to set aside the abatement or dismissal, so why this thing happened, why that plaintiff has not made application earlier before within the prescribed period of limitation, whether he was ignorant about the fact of the death of the party whose legal representative he wished to bring on record. What are the reasons for such delay? And if it is proved by the plaintiff that he was prevented by any sufficient cause, then the court shall set aside its earlier order of abatement or dismissal. But while setting aside the abatement order or dismissal order, court may impose some certain condition, especially condition relating to cost which is incurred by other parties in defending or prosecuting the suit proceeding. And when the plaintiff, suppose now this plaintiff has to make an application under this sub rule 2 of rule 9 for obtaining an order to set aside the abatement or dismissal order, previous order of abatement or dismissal. Suppose for making such application again there is some delay cause. Then again plaintiff has to make some another application for the continuation of delay, and he has to make that application as per the provision of section 5 of the Limitation Act for the continuation of delay. So it is made clear by this rule 3, it says the provision of section 5 of the Limitation Act shall apply to applications under sub rule 2. Then rule 10A, amended rule of this order 22, what it says, rule 10A, duty of pleader to communicate to the court death of a party. This rule is important. Wherever a pleader means advocate, who is appearing for any particular party, wherever a pleader who is appearing for any particular party to the suit, he comes to know about the fact of death of that party to whom that pleader represents, then that pleader shall inform the court about it. About it means the fact of death of the party to whom he represents, and the court shall thereupon give notice of such death, fact of such death, to the other party. And for this purpose the contract between the pleader and deceased party shall be deemed to subsist. That means even though that party dies, then also law treats that contract for engagement of lawyer between party and that lawyer still exists. So it is a duty of that lawyer to inform the court about the fact of death of the party to whom he represents. Then rule 11 of this rule 22 says that all these provisions relating to bringing legal representatives of the deceased party in a suit, all these provisions are also applicable to the appeal proceeding. So in case of appeal proceeding, who are the parties? Instead of plaintiff, there are appellants, and instead of defendant, there are respondents. So all these rules applicable to appeal proceeding also. Then one more related provision, it is contained in order 1, rule 10, sub rule 2. So relating to this topic of bringing legal representative of deceased party in a suit, we have to consider one more provision, but it is contained in order 1. Order 1, it is relating to parties to suit. So this provision is contained in order 1. In order 1 also there are several rules, but for us rule number 10 is important, and in that rule 10, sub rule 2 is important. So we have to consider in this respect provision contained under sub rule 2 of rule 10 of order 1. The heading of this rule is court may strike out or add parties. Court may strike out or add parties to the suit. So what this rule says? The court may at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, this this particular rule gives power to the court either to strike out the name of any party to the suit or to add any new party to the suit. So power. Court can exercise this power at any stage of the proceedings, of the suit. Then court can exercise this power in two situations, either of two situations. First situation is, suppose any concerned party has made an application before the court under this rule. This is first situation. And second, nobody has made application to the court. Court so much thinks it necessary to exercise its power to strike out the name of any party or to add any new party. So it is said that the court may means it is a discretionary power of the court. The court may at any stage of the proceeding, either upon or without the application of either party, and on such terms as may appear to the court to be just, court may order that the name of any party who is improperly joined in a suit, whether as a plaintiff or defendant, be struck out. Court may order that the name of any party be struck out. Who may be that party? He may be either plaintiff or defendant. Why to struck out? When court comes to a conclusion that he is improperly joined in a suit. Okay? And second situation, court may add the name of any person as a party to the suit. So court may order that the name of any person who ought to have been joined, whether as a plaintiff or defendant, but he has in fact not, any such person who ought to have been joined but actually not joined as a plaintiff or defendant, then in such situation also court can add the name of that person as a party to the suit, either plaintiff or defendant. Okay. What is the test for adding such a new person as a party to the suit? Such person is a person whose presence before the court is necessary. Why? To enable the court to adjudicate upon and settle all the questions involved in the suit. So presence of such person is necessary in order to enable the court to adjudicate upon and settle all the questions involved in the suit. How to adjudicate? Effectually and completely. So presence of such person is necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit. Then in that case the name of such person shall be added as a party in the suit. So this is the sub rule 2 of rule 10 of order 1. Now we will see sub rule 4 of this order, sub rule 4 of rule 2 of order 1. What it says? Where defendant added, plaintiff to be amended. So then by an order under this sub rule 2 of rule 10 of order 1, by an order of the court, when any person is added as a defendant, in the suit, then this sub rule 4 comes into picture. Any new person is added as a defendant. Where a defendant is added, then thereafter the plaintiff shall be amended. As may be necessary. Because now there is new defendant. So we have to amend the plaintiff. Plaintiff has to amend the plaintiff. And then amended copies of the summons and of the plaintiff shall be served on the new defendant. And if the court thinks fit, on the original defendant also. Means suppose there is already one defendant and one more person is added as a new defendant. Then plaintiff has to amend the plaintiff accordingly, and then summons need to be served upon the new defendant. Otherwise he cannot come to know about any such court proceedings. And if the court also thinks it necessary, summons is required to be served along with the copies of amended plaintiff also on the original defendant. So this rule 10 of order 1 talks about the power of the court to add any person as a party to the suit. There is one more important rule. It is contained in order 22. Rule 10 of Order 22, Rule 10 of Order 22 of the Civil Procedure Code. Its heading is procedure in case of assignment before final order in the suit. What is this? What is the provision? It says, this Rule 10 of Order 22 says, in other cases, that is, cases other than those of a death of a party to suit. Means we already considered the cases of death of any of the party to the suit. So now we are considering, under Rule 10, we are considering those cases other than those which are relating to the death of the party to the suit. So in other cases, in other such cases of an assignment, creation or devaluation of any interest during the pendency of a suit, the suit may, by leave of the court, be continued by or against the person to or upon whom such interest has come or devolved. This Rule 10 will comes into picture, in which case, first, suit is pending. Suit is pending before the court. While the suit is pending, the interest in the subject matter of the suit, it either that interest in the subject matter of the suit, it has been assigned by a party to the suit in favor of some third party, or by or because of the effect of any law or transaction, that interest in the subject matter of the suit get created in favor of some third party, or it devolves upon some third party. Then in that case, that third party is also important. So it is necessary to make that third party as a party in a suit, that stranger person as a party in a suit, either plaintiff or defendant, as the case may be. Suppose that person is made as a plaintiff, that means it is necessary to make him a plaintiff. That such third party who says that it is necessary for me to become a plaintiff, then he has to make an application before the court to make him a plaintiff as a party. And if the court gives permission for it, then he will be a party in a suit. So if he becomes the plaintiff, then suit can be continued by him. And suppose that stranger person it is necessary to make him dependent, that stranger person, and for that plaintiffs make an application, then in that case, with the permission of the court, suit can be continued against such third person upon whom that interest in the subject matter of the suit came to devolve. This Rule 10 of Order 22 is also more important. So I have explained the relevant legal provisions, but I will explain this topic in elaborate manner with reference to case law. So I will explain this topic in several part of my video lectures. So it cannot be finished in one video lecture. So there may be a several part of this video lecture. So I request you all, please see all these videos relating to this particular topic. So I stop here for the time being. Thank you.